All right. Good evening, ladies and gentlemen. Just gonna briefly do the cumulative midterm course review and midterm exam review, just so we can kind of recap some of the things we talked about. So we'll go ahead and, without further delay, we'll go ahead and get started. Of course, we started out with personal introductions, class introduction, or my personal introduction, of course. Um, did a writing workshop where we talked about legal writing. I'm actually going to wait till next lecture to talk about the writing assignment that was turned in. I realize it's not even due until midnight on tonight or the 17th. So at this point, I can't give you guys the answer because it's not due now for until midnight or till 11:59 at night. So I don't want to give the answer before people submit it. So you'll actually get a kind of another writing workshop slash review of that first writing assignment tomorrow. So did the writing workshop. Then we moved to chapter one, where we talked about just a general introduction to criminal procedure. I think, in a nutshell, I explained that criminal procedure is the system itself, the rules that apply, and the system. Well, in a nutshell, the rules that apply to law enforcement, the judiciary or the judicial system, and us as individuals. In other words, how the system works, how we're supposed to be treated, and everyone, the duties that everyone has. So, of course, with criminal law itself, with substantive criminal law, not criminal procedure, um, it's all about uh, us as individuals and our duty to the rest of society, like the things we're not supposed to do because the rules are set in place. Criminal procedure is about the rules that govern the system once you have um, once you've been accused of violating, or even before you're accused of violating, what even goes into the investigation process. So, what are the obligations of law enforcement? Then, once you are charged, what is now the obligation of judiciary when it comes to how the individual person that's accused of violating the law is treated and how their path move through the system. So that's what we're talking about criminal procedure. Talked about chapter two, the sources of criminal procedure. So we talked about the sources of law. First and foremost, the Constitution. Uh, most of the time, 90% of what we've been talking about has been all constitutional law. So you have Constitution, the Fourth Amendment, of course, search and seizure, talked about that. Fifth, right to remain silent. Sixth, right to due process and an attorney. We talked about how the 14th Amendment through incorporation was applied to the state, so that made the federal constitution applicable to state law enforcement and the state court system. So we talked about that. Um, also talked about how it's the judiciary's role to interpret law. So of course, you have the Constitution, which is legislative made law. If you think about it, you have actual legislative codified law, and then you have the judiciary that has to interpret that law or figure out how certain things are going to be defined and how it's going to be applied legally. So those are three of the sources of criminal procedural law. Then chapter three talked about the Fourth Amendment and searches and seizures. And of course, the general rule is that before you are searched or before your premises is searched, law enforcement must obtain a warrant based upon probable cause, that particularly specifies what they're searching for and where they're searching, including the address and everything. Same applies to arrest. So before they can arrest you, they have to get a warrant. That is the general rule. We also talked about the several exceptions to both the search and the seizure requirement that law enforcement get a warrant. So we talked about those exceptions. Plain view, of course, being one of them. Talked about if they plain view is also essentially the same thing as them actually witnessing you commit a crime. So you commit a crime in plain view of the officers. Now that also gives them not only the right to search you, but it gives them grounds to now arrest you. So that is their probable cause. So we talked about the automobile exception and it went from there. So that's search and seizures. Then we went to stop and frisk. We talked about the groundbreaking Terry case out of I think it was 1967, out of the 60s. I gave you kind of a historical background, and I even brought you as far as today when we look at stop and frisk and how it's been applied and how it's kind. I told you it may be one of the deadliest bodies of law or cases ever to come out of Supreme Court because it's led to more police citizen interaction. So it is now the reason why we can't just be left alone. So if it was just about in other words, they had to have probable cause just to stop and talk to you. There would be a whole lot of situation where cops wouldn't really be able to just stop and encounter you, which might, and this is my opinion, but it might save lives if cops can't just stop and encounter you randomly. So of course, with stop and frisk, there was a lower standard, not probable cause, but reasonable suspicion. Um, so that allowed the cops, of course, and that was based upon or justified by the court and the court's justification of it, or their rationale in the justification is the fact that the stop and frisk was not as invasive as a regular search and seizure. So essentially, it's just the cop stopping you, ask you some questions. And of course, as a part of asking you a question, they're also allowed to pat you down, of course, for their safety. But of course that kind of snowball. We talked, and I think this is a chapter where I started talking about the fact that it's a cat and mouse game with police. And I don't mean cat and mouse game in the sense that they're trying to catch the bad guy. They are trying to catch the bad guy, but it's the cat and mouse game that the police play with the law and the Constitution. So when the Constitution gives them a law or gives them a rule or a standard that they have to follow, the first thing they do is try to figure out a loophole or a way around it or a way to circumvent it to make it easier for them to now investigate and do things without being, I guess, for lack of a better word, overseen or regulated by the law. So that's kind of that cat and mouse game between law enforcement and the Constitution itself. Um, so we talk about how when the Terry case comes in, what do you think happens? The cops are going to stretch the rule as much as possible. The Terry case also, I might have left this out, applies to vehicle stops. So that's the reason when they pull you over because of Terry, they can ask you to exit the vehicle so they can question you and pat you down. That is Terry stops also apply to motor vehicles. Now it's the difference between them having you get out of the motor vehicle and going straight to searching and them having you get out of the motor vehicle just to question you and have you step out. But that the ability for you stepping out of a motor vehicle is the same as a Terry stop if you were walking down the street and they wanted to question you. So stop you in the motor, or let's say once you've been stopped. Normally, if they're going to stop you in a motor vehicle, they have to have probable cause that you've at least violated some type of traffic ordinance, unless and they can still pull you over even without that probable cause if it's based upon reasonable suspicion. So that and of course ask you to get out of the car. And then maybe a question on the midterm: what is the standard that's applied when the police officers pull you over and ask you to get out of the car? Not necessarily search the car, but that standard is reasonable suspicion and not probable cause. Because it's not a search; it's just stopping you to question you. So move on from stop and frisk. Chapter 5 is about probable cause and arrest. Same thing. We know we have the warrant requirement for arrest. We talked about certain exceptions to the probable cause and arrest. So they don't have to get a probable cause warrant when they see you committing a crime, whether it be a misdemeanor or a felony. So you can be arrested for misdemeanors as well. We talked about how the use of deadly force is a form of seizure. So when they use deadly force, it has to be reasonable. We're talking about the fact that the arrest has to be reasonable. So it has to make sense when we talk about the totality of the circumstances, the force that's used, and everything. So anytime we feel like there's been excessive force in an arrest, we're questioning the reasonableness of the arrest. So we all also question, and when we challenge arrest, we also ask whether or not there was probable cause. In other words, was there that was the standard for you even being encountered or arrested, even met? In other words, was there probable cause? And two, was it reasonable? So, in other words, did they use an amount of force that's excessive or not reasonable? So, that's what we talk about. We're talking about when we talked about probable cause and arrest. Moved on to chapter 6, searches and seizures of property. Of course, Fourth Amendment applies, but we talked about certain exceptions when it comes to property, as public property, let's say private property that is open to the public and things of that nature. So we talked about searches and seizures of property. Then we moved on to chapter 7, where we talked about inspections and regulatory searches. Of course, inspections usually deal with health and things that are highly regulated industries where they're now coming in to search, like the restaurants where they want to, the health board can come in and make sure they're up to code. We talked about regulatory searches as well. We talked about rules that apply to students in schools, basically, let's say K through 12. The fact that they're at school, that means, of course, they're kind of under the umbrella or the watch of school administration. So that means they can be searched not necessarily for the commission of a crime, but at least be searched to make sure they're within code. Of course, we talked about how in high school you have a locker that's not your locker. They got a key to it. They can run the drug sweeps or whatever. We also talked about student athletes being subjected to urine, having to give urine samples or being drug tested, and that also being a lower standard as well, or no standard at all, actually, because they've kind of signed on by being an athlete. Um, then we moved from chapter 7, the last chapter that's going to be covered under the midterm. Chapter 8, interrogation and confession. Of course, I gave as just a baseline. I spoke about the exonerated five from New York, the Central, formerly known as the Central Park Five, and I use that as kind of the measuring rod or the case that we were going to examine. We talked about interrogations and confessions. We talked about the first and foremost. They don't have to. We talked about what the where the Miranda warning came from, what case it came from. It was the Miranda case, so that's why it's called Miranda. The defendant in the case was Miranda. His last name was Miranda. He lost at trial. He appealed, but the ruling that came out of the case is the fact is simply that anytime you are in custody, you're under arrest and in custody, and law enforcement is going while you're in custody is going to formally question you and interrogate you. They have to first read you your rights. That means they have to let you know that, for one, sometimes they don't even have to tell you that you're under arrest because you know that by the facts. But they have to let you know that you have a right to remain silent. That any statement you say or anything you say or do or any statement you make can be used against you, and you have the right to an attorney appointed or retained. So they have to let you know that before they start questioning you. Then not only that, do that, but then we talk about the means of interrogating you. In other words, is it reasonable? Are they using force? Or is what they're doing? Is the interrogation mode coercive? In other words, are they coercing you to give to say certain things based upon the use of force or even psychological or just normal physical environmental stimuli? Like the room is cold. How long were you in there? So we talked about that, and that's why we even can factor in the age of the person that's being interrogated, and that's when I definitely reiterated or kind of brought up the exonerated five again, because these were young teenagers, not even old teenagers. We're not talking about 17, 18. The youngest of them was like 14 years old. So you're talking about children who are essentially subjected to interrogation. And I think I said there's no situation where that is cool. Children being interrogated without their parents being informed and being held captive kind of in a room and being interrogated. So we talked about how when force is used, the confession or statement that's given is not really reliable because it's not really given in furtherance of the truth. It's given because this person wants to get out of the situation where they're being beat or coerced. So that's where we ended chapter 8. Of course, the midterm exam will be posted on the 18th. That is tomorrow. At this point, it'll be posted at 5 p.m. Um, so let's talk about it. Just the specifics of the midterm exam. It does consist of 25 questions, including and 25 questions plus an additional extra credit question. The extra credit question is at the end. So the first 25 questions are all multiple choice, and they're worth 1 point towards your final grade. So in tallying your grade, all you need to do is keep track of the scores you get from every assignment. At the end of the semester, you add those scores together and you divide it by 100. So in other words, it's out of 100. So now there are some things that you can get extra credit on and actually have more than the allotted amount of points. So actually, in total over the whole semester, you can actually earn between the final and the midterm, because when we get to the final, it has a 5 point extra credit question as well. But you can actually rack up extra points, and you can actually, even though it's out of 100, you can get 110 out of 100 if you do perfect on everything. Good luck with that. But we hope you do perfect on everything. But uh, that's how it's graded. So with the midterm, your score is out of 25. But you can possibly get 30 out of 25, which is more than the 100%. So without further ado, let's get to it's like I said, it's 25 multiple choice questions plus an additional multiple choice question, which is worth 5 points of extra credit. You will have I gave you 120 minutes or 2 hours to complete the exam once you start. Must be completed in one sitting. So once you click on it to start, that's it. You got to finish. So you can't click in and click out of it. Once you click out, you're done. So if you have any technical difficulties, please email me to let me know there's technical difficulties. Sometimes students are kicked out, booted out of exams, or something happens. Their computer messes up or something like that. So they end up having to let me know about that, and usually I can reset your attempt and let you go, let you do it again. So just do the exam. Like it's going to be posted tomorrow at 5 p or the 18th at 5 p.m. and it'll be up until the 21st. It's Sunday the 21st at 11:59 p.m. or the end of the day, like not midnight of the next day, but right there at the end. So not it won't be the 22nd, but the 21st at the end of the day. So that gives you roughly 3 days, a little, yeah, 3 days to complete the exam. So just do the exam. I told you where to do the questions. It's 8 chapters. You know what 8 chapters is coming from. If you go to the website I gave you for the book, www.sagepub, that's sagepub.com / or the slash that goes like it's leaning to the right. Um, / Lippman, Lippman. That's lit. What that is, Lippman criminal procedure, and that's for the first edition. So just Lippman, no, not CP2, but Lippman CP, and that's it. Lippman CP. Click on that, go to the portal. You can choose, of course, you choose a student portal, and you can actually go through the book. Go through each chapter, and it has its own review for each chapter. It'll actually help you prepare for lectures and stuff as well. But then at the end, you can also click on like the quizzes. You can do little quizzes just to practice. So and just to do multiple choice to see if you have an understanding of it. Guess where I get my questions from. I literally pull them directly from those online quizzes. That's why I like this book. I like all Sage Publication books because they do that. I like Lippman and the way he does that. So it allows me to assess my students, and allows me to give them an opportunity to learn on their own independently, not only with my lectures, but go online and really focused on putting a little extra work in and just going online and being prepared. So I like that. It puts the onus on the student, because there's no reason why you should do badly in my class when I'm opening up and letting you know where the resources are. So I do like 5 of the questions. I won't number them, but I'll let you know. You do 5 of them. I'll do 5 of them. Won't give you an answer, but I ask them to you. You can get that on your own. Um, okay. The area. in which police are most likely required to have a warrant to make an arrest is A, public street, B, a suspect's home, C, a suspect's car, or D, a private business? That's one of the questions. I'll answer that. Suspect's home. Remember when we talked about the exceptions to the warrantless arrest rule and where they can arrest, where they can arrest or bust in to get a person. If a person's seen committing a crime on a public street, that's easy peasy. We see it, we're going to arrest them. A car, of course, you have the automobile exception, so you don't need a warrant up front to search a car. A private business, depending on, if a business is private, not held out to the public, they can't just bust in there. A Walmart and certain even corporate businesses are private businesses, but they're open to the public, so it just depends. So they can search it. There are situations where they can search a private business without a warrant, but there definitely situations where they don't have to have a warrant. So either they don't have to have a warrant, or they, in certain situations, they do. But definitely in a suspect's home, that is the area where you are most protected, in your home. So they are most likely required to have a warrant. Out of those four choices, the best answer is suspect's home. Next question I'm going to put forth. Which of the following are conducted to ensure compliance with government standards such as fire safety? A, special needs searches. B, administrative searches. C, sneak and peek searches. Or D, none of the above. The answer is B, administrative searches. So administrative searches are conducted to ensure compliance with government standards such as fire safety. Okay, true or false? Suspects subjected to lengthy interrogations are more likely than those who have not to provide false confession. True or false? That is true. If my interrogation is long and I'm being held, or sometimes you can be tortured without being touched, left in the same place 4 or 5 hours, no food. I'm more than likely just to say what they want and not to be accurate. So I'm more likely to give a false confession than just tell them what they want to hear. Right? That's the third question. I have two more I'm going to ask you. All right. What legal principle is used to allow courts to make law via precedent? A, stare decisis. B, habeas corpus. C, executive. Or D, judicial. And the answer is A, stare decisis. So what legal principle is used to allow? So stare decisis is the legal principle used to allow courts to make law via precedent. So stare decisis just means we're going to follow what's already there, or what's been set before us, which is precedent. So they're interchangeable words. One more question. All right. Okay. What level of proof is required for police to order the driver of a vehicle to step out? Just talked about this, I think. A, hunch. B, preponderance of the evidence. C, reasonable suspicion. I'm sorry. Or D, probable cause. The answer is C, reasonable suspicion, which is lesser than probable cause. So they don't need probable cause or search warrant or even probable cause in general to ask you to step out of the car for questioning. All they need is reasonable suspicion. So having you step out of the car, the driver step out of the car is tantamount to the Terry stop. It's like the motor vehicle version of the Terry stop. So that is five of the 25 questions. So good luck to you guys. Like I said, you have an hour and 20 minutes in which to complete it. But good luck to you guys. More lectures will be dropped next week, so they'll be out next week. So we'll start back on the after you do the midterm on the 22nd. We're jumping into actually we're going to doing 3 chapters at night, 9, 10, and 11. So we're going to start doubling up chapters because we're cutting it close to the end. So we're gonna be doing that. So we're gonna be doubling up, actually tripling up chapters. Coming up, going into the end of the summer session. So got one more discussion board left. There's actually one up tonight, so you need to do that. The last discussion board is on the 24th. Then we finish on the 25th with chapter 15, counterterrorism. Then from there, we start doing course reviews. Follow your syllabus. This is the syllabus. Hopefully you can see that. That's why I asked you to print it out. It's more important to have a syllabus in the class or online class like this than it is an in-person class, because in an in-person class, you're going to see me in person more often. But in this class, you don't. So you want to rely on that syllabus because I follow it. So without further ado, I'll go ahead and end this. You guys, good luck on the exam and take care. We'll see you next week.